Counsel, you began by saying, the platforms, they want to keep out this person and that person on the basis of race or sex, and then you said that's not the First Amendment. Well, the First Amendment doesn't apply to them. The First Amendment restricts what the government can do. And what the government's doing here is saying you must do this, you must carry these people, you've got to explain if you don't. That's not the First Amendment.
Well, respectfully, Your Honor, the First Amendment is big, and it applies in a lot of different ways. So it's true for us, like we're saying, because this isn't speech, it's conduct, we can require viewpoint neutrality. But in other cases, the same companies are saying when New York or some other state says, hey, you can't have algorithms that try to hook kids, they say, well, we have a First Amendment right to do that. It's the same First Amendment that says, if it's all First Amendment, then I guess it's going to be hard for Texas to say you have to be viewpoint neutral, but it's also going to be hard for California and Illinois or anybody else to say you can't have an algorithm that hooks kids, because it's all the same.
I'm sure it's the same for all the other states. The question is, they don't have the obligation to act in the same way that you as the state has the obligation to do. They can discriminate against particular groups that they don't like, whether it's a group that encourages kids to take the Tide Pod contest or something else, and you have different obligations.
I guess a couple ways I could respond to that, Your Honor. The easiest one I'm going to talk about is, if I may, common carriage. My reaction coming to this case was the same as yours. My reaction was, well, wait a minute. It's their own platform. You can't censor, like they're private. But that's the exact same scenario that came up with the Telegraph. The idea that Telegraph was dumb pipes is not true. Instead, what the Telegraph was is they had the technological ability to say that we're not going to let this type of speech through.
No, you're absolutely right, but it's kind of begging the question. You're assuming that they're like the Telegraph. It seems to me that that's a big part of what the case concerns. And I'm just not sure that, the Telegraph had particular compelling type of monopoly. If you didn't want to use the telegraph that was there, you usually didn't have an alternative choice, or whether you're talking about railroads or other types of common carriers. I'm not sure the same thing applies with respect to social platforms.
So I give you my theory for why common carriage is important here. As I look at the cases, and I agree, they're really hard to figure out where conduct starts and speech ends and all of that. And you look at all of the various cases this Court has said, some commentators say they can't be reconciled. I'm not sure about that. But I think it's a helpful way to think about it is we know that there is a line between speech and conduct. And we know that common carriage has always been on the non-speech side of the line, the conduct side of the line. So if this falls within the common law tradition of what is common carriage, nobody has ever thought that falls on the speech side of the line. So we can't make them, say something otherwise that they didn't want to say. The whole point of it is that's a signal to the court. That's a way that the court can figure out which side of the line are we on.
Well, it turns on whether you're saying who do you want to leave the judgment about who can speak or who can't speak on these platforms, and do you want to leave it with the government, with the state, or do you want to leave it with the platforms, the different various platforms?
Well,
the First Amendment has a thumb on the scale when that question is asked.
It does, and that's why it's important, I said, to go back to look at the history on this, because at some point the First Amendment has to end, or everything is covered by the First Amendment. This Court has said that the way that we tell the difference is whether it's inherently expressive. And the Court has said what they mean by inherently expressive. They talked about in Miami Herald, you're not a passive conduit. We talked about in Hurley whether you're intimately connected. Well, this Court last year had a case in Tamna where they talked about what these platforms do, and they say that they are passively connected to the speech on their platforms, and that they're agnostic about the content. It's just one big algorithm that's matching things together. And I think that's important. But I also want to stress, if I may, again, this is a facial posture, and if you look at the breadth of our statute, there's the talk about whether you have to host somebody's speech. There's also about you just want to read Facebook. That is one of the provisions of our statute. You go online in the morning and you want to see what's going on in the world. According to their theory, they can stop you from doing that, too. And that's surely public accommodation law. The idea that they don't like somebody because of their race or their disability or something like that, and we're going to say we're not going to allow you onto our platform, that surely cannot be constitutional. That's what I mean by that's Lochner. That's you've gone beyond any content of the platforms themselves on their page to saying we're not going to let people even look at what we're selling. That's a bookstore saying we won't sell you our book. That's different from saying we won't publish your book.